Welcome, ladies and gentlemen. We're glad you could join us today. Welcome to another webinar hosted by thinc, the Hague Initiative for International Cooperation, and this will be the first webinar in 2024. We invite you to join us on our monthly webinar, the last Tuesday of every month throughout the entire year. On today's session, our distinguished guest is Professor Steve Zipperstein. Professor Steve Zipperstein is a lecturer in the Global Studies program at UCLA and a visiting professor at Tel Aviv University Law School. In addition to being an author, his very rich and impressive curriculum, Professor Zipperstein is also a distinguished fellow, senior fellow of the UCLA Center for Middle East Development. For the new joiners, welcome. thinc stands for the Hague Initiative for International Cooperation. It is a global network of international law academics, practitioners, and experts in related disciplines. thinc was founded in 2017 in The Hague, the global capital of international law, and we challenge the misuse of international law to delegitimize the state of Israel and advocate international law for peace and security between Israel and her neighbors. International law is a major weapon used by Israel's adversaries, and misuse of it is an existential threat to the Jewish state. We achieve our mission through research, education, and policy. Thank you for joining us today. Our moderator, and today as in every webinar, is thinc's director, Advocate Andrew Tucker. Hi, Andrew. Good evening.
Sylvia, thank you so much. Welcome, everybody. It's great to have so many of you on board, wherever you might be around the world. Welcome to this thinc webinar. We are at a very critical moment in the history of the Middle East, generally of the world, and certainly of the state of Israel. There's no other country that over recent decades has been such attention given to it as the state of Israel in the United Nations system and in the global community generally. And the current Gaza conflict has heightened this attention on Israel. We're seeing around the world calls for liberation of Palestine from the river to the sea. This is a call which is joined not only in the streets of major cities in the West and elsewhere, but also across international institutions. And it's a call for the destruction, or at least the dismantling, of the Jewish state of Israel. And I think it's probably not unfair to say that there's a kind of a legal war going on regarding the state of Israel. There are currently 3 cases pending or active before the International Court of Justice. We're going to look at 2 of those this evening. There is a proceedings called the Situation in the State of Palestine at the International Criminal Court, another institution also here in The Hague. We have the UN Human Rights Council has a special rapporteur who almost on a daily basis is condemning and criticizing Israel for breaches of international law. It has a permanent commission of inquiry staffed by, I think, over 30 full-time people in Geneva who are looking daily at how Israel is committing war crimes and crimes against humanity. We have legal cases going on in a number of national states. We have the UN Relief and Works Agency for Palestine Refugees in the Near East, UNRWA, which is a unique system for refugees. Palestinian refugees are the only refugees who have a so-called right of return. The UN Secretary General, Guterres, is constantly, very frequently calling for a 2-state solution, an end to the conflict, taking positions on legal issues. And we have a UN Committee on the Exercise of the Inalienable Rights of the Palestinian People. If you can pronounce that, you're doing extremely well. I'm having difficulties. But this institution was created to defend and promote the Palestinian cause within the United Nations. It's daily talking about Israeli crimes and breaches of international law. So Israel is somehow subject to this constant scrutiny, criticism, and condemnation based on law. Let's just step back for 2 minutes. I'm just going to introduce for 5 minutes before handing over to Professor Zipperstein, who's going to lead us into the cases currently before the International Court of Justice. Extremely important. But in order to do that, let's just look at the bigger picture. In 1918, at the fall of the Ottoman Turkish Empire, the territories of the Middle East, the former Ottoman Empire, devolved to the Allied powers under international law at that time. Same with the German territories of the defeated German Empire. And at the Paris Peace Conference, the Allied powers decided to create mandates, one of them being the mandate for Palestine, which was intended to create a Jewish homeland in Palestine with respect for the civil and religious rights of all peoples in the region. In 1922, that mandate was created and adopted by the League of Nations. There was a Palestinian Arab leadership movement which opposed this and consistently condemned the mandate for Palestine, the Balfour Declaration, everything that was giving rise to the Jewish homeland. But as a matter of law at that time, there's no doubt that this was creating the legal foundations of a Jewish home in Palestine. In 1947, after the Second World War, after the Shoah, the Holocaust, the destruction almost of European Jewry, the UN adopted the partition plan after the British had left Mandate Palestine. They gave up, handed the matter over to the UN, and after a series of committees of inquiry, the UN General Assembly adopted an idea, a plan, to partition Palestine into a Jewish state and an Arab state, with Jerusalem as a kind of international state and an economic union between these states. Jerusalem as an international city, not a state. This partition plan was an idea, a proposal. It was rejected by the Arabs and accepted by the Jews. It was never implemented. 6 months later, after war, the State of Israel was declared upon the very day that the mandate for Palestine came to an end. The British had left. The Jews declared their state, the Arabs did not. And from that moment on, there's been a kind of war within the UN about this idea of Palestine. We've seen wars, aggressive wars by the Arab nations against the State of Israel, right up to the Yom Kippur War of 1973. Now, in June 1967, after the Six-Day War, I just want to throw this in because I think it's terribly important to understand. Israel won control of Judea and Samaria, the West Bank, and Gaza Strip and the Golan Heights, and the whole city of Jerusalem. It made a very strategic decision. Three things. First of all, it decided to incorporate East Jerusalem into the State of Israel. It applied Israeli law and jurisdiction to the whole city of Jerusalem. Secondly, decided to treat the West Bank as occupied territory. That was an Israeli decision in the belief that this would comply with international law and appease the Arab people, and that Israel would negotiate land for peace. And thirdly, they decided to allow and enable Jews to live in the occupied territories in the belief that this is allowed under international law. Then we had the Yom Kippur War of October 73, a turning point in the history, also the legal history. In the meantime, the PLO had been created, the Palestine Liberation Organization, 1964, before the Six-Day War, to liberate all of Palestine from the Zionists. In other words, to destroy the State of Israel. That is today still the charter objective of the PLO. Israel is trying to negotiate with this entity, which is trying to destroy it. In 1993, we had the Oslo Accords. And since then, there have been a raft of endeavors to try and reach an agreement with the Palestinians. We've seen the Abraham Accords, some normalization with Arab states, but we also see radical Islamist jihad states like Iran, like Qatar, supporting terror against Israel, supporting Hamas, Islamic Jihad, and others who are seeking to destroy the State of Israel. So in these legal cases currently before the Court of Justice, and also other institutions, but especially the Court of Justice, the courts will be deciding on a number of legal issues. Is the occupation legal? To whom do the so-called occupied territories belong? Does Israel have any legal claim of sovereignty to East Jerusalem? to the West Bank, so-called, or to the Gaza Strip or the Golan Heights? Is it legal for Jews to live in these territories outside the Green Line? What is the status of the old city of Jerusalem? Is Israel committing genocide against the Palestinians? Is the Jewish state of Israel an apartheid state? All these fundamentally legal issues going to the very heart of the existence and legitimacy of the state of Israel. So I think we're touching and entering into a season of lawfare against Israel, and we want to explore in these webinars these issues. And there's no person better, I believe, to do that and to kick off this series than Professor Steve Zipperstein. Now, many of you are avid readers, and I think this is a good thing. There's a lot to understand. Steve is the author of two very important books published by Routledge. Highly recommend that you get hold of them. 221, a book called Zionism, Palestinian Nationalism and the Law, 1939 to 1948. And his book prior to that was Law and the Arab-Israeli Conflict, The Trials of Palestine, from 2020. And his third book in this series will be published by Routledge in the coming months. It's called The Legal Case for Palestine, A Critical Assessment. Look out for that book. And as soon as you see it on Amazon or anywhere else, make sure you purchase it. So without further ado, it's a pleasure to invite Professor Steve Zipperstein all the way from sunny California. Steve, welcome to this thinc webinar.
Thank you, Andrew, very, very much for your very kind words and for your shameless plugs for my books. Appreciate that. Good evening, everyone in Europe. Good day to those of you here in North America or wherever you may be. It's a pleasure to be with you. I want to thank Andrew and thinc for inviting me, and I want to commend Andrew and thinc for the incredibly important work that they are doing in this area. So without further ado, let me put my slides up and we will begin. You see here a photograph of the interior of the Peace Palace in The Hague, the home of the International Court of Justice. And as Andrew said, we're going to talk about two cases before the court right now that are extremely important. But before we do that, let me show you this map in pink there of the Gaza Strip. And I wanted to just dispel, with your permission, a couple of the prevailing misconceptions that are repeatedly stated in media coverage of the ongoing war. For example, the BBC and Sky News and Al Jazeera, the New York Times and others always say that Gaza, and it's not clear whether they're referencing Gaza City or Khan Yunis or the entire Gaza Strip, they always say Gaza is the most densely populated area in the world. And that's simply not true. 2.1 million people, 140 square miles. The density of population is far, far greater in places like Manhattan or Mexico City or Sao Paulo or Mumbai or Delhi or Jakarta. It's just not true that Gaza is the most densely populated place in the world. In fact, Gaza City does not even make the list of the top 50 most densely populated cities in the world. Another misconception is that Gaza is somehow under occupation by Israel. That's blatantly false. Israel withdrew completely from Gaza in September of 2005. There has not been a single Israeli settler or soldier in Gaza, except after October the 7th, when the Israeli army in the third week of October came in a legitimate act of self-defense. We'll talk about that more in a minute. Another misconception is that the Israelis have been illegally blockading Gaza for years. That's not true. In fact, the United Nations commissioned a blue ribbon panel co-chaired by Sir Geoffrey Palmer, the former Prime Minister of New Zealand, and Alvaro Uribe, the former president of Colombia. They issued a 100-page report several years ago in which they said that the Israeli naval blockade of Gaza was absolutely legal and permissible under international law. Why? Because Hamas had been firing rockets indiscriminately into Israel ever since violently ousting the Palestinian Authority from power in June of 2007. And then the final misconception that we hear a lot about Gaza is that it is the largest open-air prison in the world. In fact, we now know, of course, that Gaza is the largest terrorist base in the world. October the 7th was the worst day for the state of Israel and for the Jewish people since the Holocaust. And I thought it would be helpful to put into American terms what happened in Israel on October the 7th. At least 1,200 Israelis slaughtered by the Hamas terrorists. In American terms, that would be 42,000, more than 10 times what happened on September 11, 2001. 7,300 Israelis were wounded. That would equate to more than 250,000 Americans in a single terrorist attack. Of course, we now know, and confirmed by the New York Times and The Guardian, newspapers not exactly pro-Israel, we now know of the absolutely horrific sexual violence that the terrorists perpetrated on October the 7th, 2023. And shame on the UN, shame on the women's organizations around the world for remaining silent in the face of the sexual violence. 243 people were taken hostage on October the 7th to Gaza. Of course, some have been released. Unfortunately, some have died. But 243 hostages would be the equivalent of 8,500 Americans. And of course, let's not forget that the Hamas attacks of October 7th occurred under the cover of thousands of rockets fired from Gaza into Israel, thousands more since then. That equates to almost 5 million rockets fired inside the United States from terrorists along our border. And of course, 200,000 Israelis internally displaced, forced to flee their homes, both along the Gaza border as well as the Lebanese border. That would equate to 7 million Americans. And so let me ask you all, just to close your eyes and imagine for one moment, what do you think the United States of America would have done in response to an attack like this? Well, Israel, lawfully acting within its rights under Article 51 of the United Nations Charter, embarked on a defensive campaign against Hamas in Gaza and has been conducting that campaign with one hand tied behind its back under pressure from the United States and the international community to avoid civilian casualties. Israel, of course, its military doctrine dictates that civilian casualties are to be avoided at all costs. The international media has been reporting without criticism the casualty numbers supplied to it by Hamas. You remember when the media accused Israel of bombing a hospital in Gaza and killing 500 people. It turned out the hospital was bombed by an errant Hamas rocket, and the death toll was closer to 50. And so if we now look at the supposed 25,000 casualties that the Hamas-controlled health ministry reports, if you use the kind of same proportion, 500 to 50, that would be more like 2,800, not 28,000. We know, though, that the 28,000 includes somewhere around 9,000 dead Hamas terrorists. And so the bottom line is that we do not have reliable casualty figures regarding civilian deaths and civilian injuries in Gaza. But notwithstanding that, the Republic of South Africa came to the International Court of Justice, and this is the first of the two cases we'll talk about, in late December of last year, December the 28th, and filed a document initiating a case accusing Israel of violating the Genocide Convention of 1948 by virtue of Israel's lawful war of self-defense in Gaza. And South Africa requested the International Court of Justice to impose or indicate, in the parlance of the ICJ, to indicate so-called provisional measures against Israel, including ordering Israel to halt its ongoing military activity in Gaza. And in parentheses there, I say that provisional measures would be kind of akin to seeking injunctive relief. and I'll talk more about that and what that means in a minute. These are the 15 judges who sit on the International Court of Justice. The court was created in 1946 after World War II. It's governing statute, part of the United Nations Charter. The first international court was created after World War I. It was then known as the Permanent Court of International Justice, now the International Court of Justice, which, as I said earlier, is based in The Hague. 15 judges, they each serve for a 9-year term. As you see here, 4 of the judges' terms are expiring next month. The American judge is the presiding judge of the court, Joan Donahue. Her term expires next month. And you can see the various countries where they come from: Russia, China, some European representatives, and then along the bottom, Lebanon, Morocco, Somalia, Uganda. So what exactly is South Africa accusing Israel of at the International Court of Justice? A laundry list of bogus, false allegations of Israeli genocide perpetrated against Palestinians. I won't read through all of this, but a couple of them really stand out. The first one, that Israel is killing Palestinians in Gaza, and quoting from the South African brief, including a large proportion of women and children, some of whom appear to have been summarily executed. That is an absolutely false accusation. It was reported by the BBC. The BBC actually retracted and apologized for having reported that, but nevertheless, it ended up in South Africa's document filed with the International Court of Justice. And then let me take you all the way to the bottom of the page there. South Africa accusing Israel of imposing measures intended to prevent Palestinian births in Gaza through reproductive violence. No evidence whatsoever for this allegation. This gives you a sense of what South Africa is accusing Israel of. And you might be thinking, why South Africa? Why did South Africa file this case? There has been some reporting in the media in South Africa that the ANC, the governing party, which has been having tremendous problems, including financial problems, has been in contact with Hamas. We know a Hamas delegation went to South Africa on a so-called solidarity visit less than 2 weeks after the October 7th attacks. There are rumors in the media in South Africa that Iran or others may be funding the ANC to bail it out of its financial problems, and that in return, South Africa brought this case. But I would also mention, though, that despite his wonderful legacy, former President Nelson Mandela, after he was released from captivity in 1994, immediately took the Palestinian cause under his wing. South Africa, of course, at the Durban Conference in 2000, hosted a very anti-Israel conference that that gave birth to the boycott, divestment, and sanctions movement. So for a long time, South Africa has been adversarial to Israel. And here is a list of the key provisional measures that South Africa is asking the International Court of Justice to indicate or to order against Israel, including an immediate suspension of military operations. And again, I won't go through all of this, but one I want to point to, the fourth bullet here, that Israel must not deny or restrict access by fact-finding missions to Gaza. In other words, South Africa is asking the International Court of Justice to make a finding that Israel is plausibly violating the Genocide Convention. The case will move forward on the merits in the future, and South Africa wants the court to order Israel to allow investigators, presumably from the UN, from some of those anti-Israel bodies that Andrew mentioned, to come to Gaza to gather evidence to be used against Israel in a future proceeding on the merits. In addition, of course, South Africa requesting that Israel allow food, water, humanitarian assistance, which is currently happening now, the Israelis allowing that assistance to come into Gaza. Well, the case on the indication of provisional measures was fast-tracked at the International Court of Justice. South Africa began the case on December the 28th. The court heard arguments a week ago Thursday and a week ago Friday, and I will take you inside the courtroom in a minute to see a sample of those arguments. Note that proof of genocide under that Genocide Convention of 1948 requires evidence of acts committed intentionally to destroy a national, ethnic, racial, or religious group. South Africa had zero evidence, no evidence at all of any such intent by the Israeli government, other than supplying a couple of quotes from a couple of Israeli government officials or members of the Knesset talking about striking a hard blow against Hamas, destroying Hamas, etc. Those quotes do not in any way, shape, or form satisfy the requirement to prove intent. However, because we are at a very early stage of the case, and South Africa is asking for the court to indicate provisional measures, all South Africa has to show is a, quote, plausible basis to believe, not proof of intent, but a plausible basis to believe that Israel may be violating the Genocide Convention. If we were in a courtroom in the United States of America, a party seeking an injunction would have a much higher burden of proof. The party would have to convince the judge that their case on the merits is likely to succeed. So this very, very low plausibility standard at the International Court of Justice is just an unfortunate attribute of the way the court operates. And by the way, the court did the same thing when Ukraine a year or two ago, in the wake of the Russian invasion of Ukraine in February of 2022, Ukraine came to the International Court of Justice asking for the court to indicate provisional measures against Russia. And the court said here in the italicized language in the first two bullets that all Ukraine needs to show at this early stage is that the alleged violations are capable of falling within the provisions of the convention, and that Ukraine at the bottom there need only decide, or the court need only decide, whether the rights claimed by Ukraine on the merits are plausible. And that's this very, very low standard. So let me take you now inside the courtroom. Let's take a look at a little bit of the argument by one of the South African lawyers against Israel. This was a week ago Thursday in the ICJ. Here we go.
Which is one of the most densely populated places in the world, is home to approximately 2.3 million Palestinians, almost half of them children. For the past 96 days, Israel has subjected Gaza to what has been described as one of the heaviest conventional bombing campaigns in the history of modern warfare. Palestinians in Gaza are being killed by Israeli weaponry and bombs from air, land, and sea.
Okay, so that gives you a sense of the argument made by one of the South African lawyers. And now you're looking at Tal Becker, one of the greatest international law practitioners in the world. He is the legal advisor to the Israeli Foreign Ministry. He was the lead Israeli lawyer. He gave his argument the following day, a week ago Friday, and let's hear a little bit of Tal Becker.
Madam President, distinguished members of the court, it is an honor to appear before you again on behalf of the State of Israel. The State of Israel is singularly aware of why the Genocide Convention, which has been invoked in these proceedings, was adopted. Seared in our collective memory is the systematic murder of 6 million Jews as part of a premeditated and heinous program for their total annihilation. Given the Jewish people's history and its foundational texts, it is not surprising that Israel was among the first states to ratify the Genocide Convention without reservation and to incorporate its provisions in its domestic legislation. For some, the promise of never again for all peoples is a slogan. For Israel, it is the highest moral obligation.
And he goes on for another hour and a half or so. Obviously, I'm not going to play all of it for you, but let me just say that in that argument that Tal Becker delivered to the court on January the 12th, I think in that moment, he emerged as the greatest spokesperson in the English language for Israel since the great Abba Eban. Let me now move to the second case that Andrew mentioned, which deals with the legality of the Israeli occupation and the other issues that Andrew mentioned. On December the 30th, 2022, the United Nations General Assembly requested the International Court of Justice to render an advisory opinion on the two questions that are here. And let me just read both of these to you with your permission. First, what are the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination, from Israel's prolonged occupation, settlement, and annexation of the Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, character, and status of the holy city of Jerusalem? And second, how do the policies and practices of Israel referred to above affect the legal status of the occupation, and what are the legal consequences that arise for all states in the UN from this status? Now, you might be asking yourself, wait a minute, the UN, in asking this question, the way it's worded, seems to have already decided the answer. So why do they need the International Court of Justice to give them an advisory opinion? The court is there to advise the UN on legal issues for which the UN doesn't know the answer and needs advice. And yet here the UN is presuming to telegraph the answer to the court. Be that as it may, the court has ordered briefing. The parties have filed briefs. And in fact, beginning on February the 19th next month, there will be oral arguments in the court on those two questions. Andrew mentioned some of the key history. I won't repeat everything he said, but let me reiterate that the mandate for Palestine, unanimously adopted by the Council of the League of Nations on July 24th, 1922, in its preamble, proclaimed that the Jewish people have the legal right to, quote, reconstitute their national home in Palestine, not to be settler colonialists, not to come in from Europe and oust the local people, but to go back to their home, to go back and reclaim that which was theirs in ancient times. Notwithstanding that, as Andrew said, the local Palestinian Arabs fought against the will of the League of Nations, massacring 65 innocent Jews in Hebron in August of 1929. And then over the years, the crucial decade between 1937 and 1947, rejecting multiple offers of statehood. The original two-state solution offered by the Palestine Royal Commission in 1937. The original one-state solution, which the British government offered to the Palestinians in the infamous May 17, 1939 white paper, the white paper which banned Jewish emigration from Europe to Palestine, trapping millions to the Holocaust. That same white paper offered one state to the Palestinians within 10 years, and the Palestinians rejected it because they wanted statehood immediately. They didn't want to wait for 10 years. And then the UN, as Andrew said, on 29 November 1947, Resolution 181, again offering the two-state solution, and again, the Palestinian Arabs flatly rejected it. Those rejections implicitly waived Palestinian sovereignty over the West Bank and Gaza, and the Palestinians went further and made those waivers explicit, not once, but twice. In December of 1948, at a conference in Jericho, 2,000 Palestinian notables, civil society leaders gathered, and rather than asking for statehood in the West Bank, they asked the King of Jordan, Abdullah I, to annex the West Bank, thereby explicitly waiving any Palestinian claim to sovereignty. And again, as Andrew mentioned, the Palestine Liberation Organization, formed in May of 1964, adopting their original charter, Article 24 of which says the PLO, quote, I'm quoting them, not me, the PLO does not exercise any regional sovereignty over the West Bank or the Gaza Strip. I would also note that between 1948 and 1967, Egypt occupied Gaza. Jordan occupied the West Bank. And not once, let me repeat, not once between 1948 and 1967 did the Palestinians ever demand statehood in the West Bank and Gaza. Not once did the United Nations ever demand Palestinian statehood or take any steps whatsoever toward the two-state solution in the West Bank and Gaza. Not once. Until June of 1967, when Israel, as a result of the Six-Day War, replaced Egypt as the occupant of Gaza until 2005, and replaced Jordan as the occupant of the West Bank. And in November of 1967, several months after the Six-Day War, the Security Council adopted Resolution 242. This is the governing law for the conflict. The resolution says that two things must occur. One, Israel should withdraw from the occupied territories. And number two, all of Israel's neighbors and all parties in the region must terminate all claims or states of belligerency, must respect the sovereignty, territorial integrity, and independence of every state, including Israel, and the right to live in peace within secure and recognized boundaries. Well, Israel withdrew completely from Gaza in September of 2005. Did Israel receive any of this in return in paragraph 2 below from Hamas? No, absolutely not. Have all of Israel's neighbors made peace with Israel? No. Saudi Arabia? No. Iraq? No. Syria? No. Lebanon? No. And so the conditions precedent laid out by the UN in 242 for Israel to withdraw have not yet been met. I would also note that there is no time deadline specified in this resolution for Israel to withdraw. And so the answer to the questions that the General Assembly asked the ICJ, the Court of Justice, to opine on, the answers are found right here in Resolution 242. And they're also found in the Oslo Accords in 1993 and 1995, when Yasser Arafat and Mahmoud Abbas, Abu Mazen, negotiated for, bargained with Israel for the situation that we have today. The PLO agreed to divide the West Bank into three areas, A, B, and C, leaving Area C, about 60% under Israel's exclusive control. The PLO bargained for and agreed that until a permanent status agreement was negotiated, the Israeli settlements could remain in place, the occupation could continue, and the PLO at Oslo did not bargain for and did not obtain any right to statehood or self-determination. Now, maybe that would be the outcome of permanent status negotiations, but they obtained no guarantee of statehood or self-determination. And so again, I would refer the International Court of Justice to the Oslo Accords, which, by the way, also lay out a very detailed process for resolving any disputes that might arise between the Israelis and the Palestinians. Those are set forth in the first 3 bullet points on this page. And most importantly, in no event, I say this at the bottom, in no event do the Oslo Accords permit anyone, Israel, the Palestinians, or anybody else, to sue or initiate legal proceedings at the International Court of Justice, the International Criminal Court, or anywhere else. And so the answer to the International Court of Justice ought to be that they don't have jurisdiction over the conflict. The Palestinians bargained for and agreed at Oslo that if there were any disputes, they would resolve them through negotiations with Israel and not through litigation. Let me also note the reference to Jerusalem and the request for the advisory opinion from the General Assembly to the International Court of Justice. Very interesting how Jerusalem has magically transformed from occupied Arab territory in Resolution 446 in 1979 to occupied Palestinian and other Arab territory a year later. And most recently, in December of 2016, in Resolution 2334, the word Arab has been dropped entirely by the UN, and now Jerusalem is referred to solely as occupied East Jerusalem that is solely occupied Palestinian territory. And the question I would ask is, at what point along the way did East Jerusalem magically transform itself from an area that had been occupied by Jordan to Palestinian territory after it had been occupied by the Ottoman Empire for 400 years between 1517 and 1917? So this is my last slide, and I'd love to take your questions. These are the compelling legal conclusions based on the history that Andrew and I have discussed and based on international law. Number one, Israel's occupation of the West Bank is not illegal. In fact, it is perfectly permissible under the Hague Convention and the Hague Regulations of 1907. Number two, the mere duration, length of the occupation does not render it illegal. As I said, there's no deadline in Resolution 242. And compare that to Turkey's occupation of northern Cyprus, which has been ongoing since 1974. You don't hear anybody say that that occupation is illegal because of the duration of the occupation, going on 50 years now. As I said just now, Jerusalem has never been Palestinian territory. Israel's legal claim, as Andrew mentioned, to West Jerusalem is rock solid. And I would argue that even if Israel doesn't have a perfected claim of sovereignty to East Jerusalem, its claim is certainly superior to the Palestinian claim. And then finally, therefore, going back to the request for an advisory opinion, the only, quote, legal consequences for states and for the UN ought to be to insist that Israel's neighbors, all of them, comply with Resolution 242 by ceasing their belligerency toward Israel and recognizing Israel's right to live in peace within secure borders, free from threats or acts of force and the kind of horrific violence that we saw on October the 7th. I'll stop there and thank you so kindly, Andrew and Thinc, for your invitation. Thank you for your attention, everyone. Would love to hear your questions. Thank you.
Thank you so much, Steve. Well, there are lots of questions coming in. Can I just kick off, Sylvia? You're going to field some of the questions. I just want to ask one question before we get into others, and that is that what is the status, Steve, of the International Court of Justice in the UN system? If it comes out with a ruling on the genocide case, which it will, even on provisional measures, and if and when it comes out with an advisory opinion, how binding are they on the state of Israel and on the international community?
Okay, let me take the second one first. The advisory opinion would not be binding. Advisory opinions by their nature are non-binding. And as I said, there are many reasons why the court should not issue the advisory opinion, lack of jurisdiction, and so forth. On the South Africa case, the opinion on indication of provisional measures would theoretically be binding, but it cannot be enforced. The International Court of Justice doesn't have a police force, has no way of enforcing its rulings. It would obviously, though, be a very, very big PR blow to the state of Israel. You know, it is really quite shocking and perverse when you think about it for anyone to accuse the Jewish state of genocide, as Tal Becker mentioned at the beginning of his argument. Clearly, the purpose here that South Africa and others who are now joining the fray, Indonesia, Mexico, Colombia, others, the purpose is to shame Israel, to isolate Israel, to essentially delegitimize Israel, and that will obviously supercharge the BDS movement. There could be consequences for Israel's access to markets, to international banking, and so forth. But the court itself does not have the power to enforce its rulings.
Thank you so much. Sylvia, over to you. I could see various questions coming in.
Yes, there are many questions coming in, and everyone is welcome to send in their questions, and we'll try to relate to all of them. I would like to connect two questions that I think you will be able to answer together. The first one would be, free Palestine from the river to the sea. Does this not violate Article 1 of the UN Charter? And the
Yes,
second one...
Sorry.
So go ahead. Yeah, go ahead.
It does violate Article 1, which is the foundational principle of the UN respecting the integrity of states, and to call for the destruction of the state of Israel is a clear violation of Article 1. Great question.
And can you clarify, please? Hamas has incorporated genocide on the Jewish people in its charter. Why does nobody bring that up?
Yeah, it was brought up by Tal Becker in his argument. The Hamas charter calls not just for the destruction of the state of Israel and the murder of all Israeli Jews, but for that matter, for the murder of all Jews worldwide. And Tal Becker did mention that in his argument.
Okay.
There's just one thing. This part of the problem we have is Hamas is a non-state entity. It's not even quite clear what it is. It's a movement. It's an organization. Clearly, it's a network. It must comply with international law. It's a subject of international law, so it too must comply with international humanitarian law, international criminal law. It's not a state, so it's not bound by the rules of international law that apply to states. It doesn't have standing, so it can't be charged with infringing the Genocide Convention because it's not a party to the Genocide Convention. What would be interesting, though, would be an argument that the PLO Palestine, which I believe has become a party to the Genocide Convention, is breaching the Genocide Convention because Palestine claims to be in control of Gaza, that Gaza is part of Palestine. So why can't a claim be brought against the so-called State of Palestine, or the PLO, for infringing the Genocide Convention? Steve, do you have a view on that?
Yeah, this gets very tricky and very complicated. I would say it this way. Palestine, the Palestinian Authority, certainly is a party to the Rome Statute. They acceded or ascended to the Rome Statute. And that is the governing statute for the International Criminal Court. That statute defines the crime of genocide in a manner similar to the Genocide Convention of 1948. It adds some other aspects as well. But I think it's more accurate legally to say that Hamas, which ousted the PLO or the PA in a violent, very violent, bloody overthrow in June of 2007, that Hamas is the governing authority for Gaza. Gaza may not be a state per se, but Hamas is responsible for everything that happens inside Gaza. Hamas is responsible for using innocent Palestinians as human shields. Hamas is responsible for diverting billions of dollars of foreign aid and constructing hundreds of miles of tunnels, attack tunnels underneath Gaza, rather than using that aid to benefit the civilian population in Gaza. Hamas is responsible for firing thousands of rockets indiscriminately at Israel. Hamas is responsible for October 7th and bears the responsibility for what has happened since then. And so if anyone ought to be in the dock of international justice on any theory, it ought to be Hamas, including the leadership of Hamas, harbored by the government of Qatar, Ismail Haniyeh and his cohort ought to be brought before the bar of justice, as well as Yahya Sinwar, the leader of Hamas in Gaza, and all the terrorists who committed their crimes. I would remind the audience that, speaking from an American perspective, 31 Americans were among those murdered on October the 7th. Americans were taken hostage. That triggers extraterritorial American jurisdiction over all of the individual people I just mentioned, as well as Hamas itself. And I'm not privy to anything happening in Washington, D.C., but if history is any guide, I would expect the United States Department of Justice to be actively looking at measures that can be enforced against those individuals as well.
Yeah.
Okay. There are many excellent questions coming in, so I'm going to try to choose some of them. What is your opinion of the merit of Malcolm Shaw's argument under the jurisdiction of the ICJ because of the lack of dispute within the meaning of the convention?
I think it's a great argument. South Africa tried to address that in their brief that they filed on December the 28th, talking about various diplomatic messages and notes that they had sent to Israel to try to create jurisdiction where there really is none. Malcolm Shaw, just for those of you, the wigged lawyer sitting next to Tal Becker in the video, Malcolm Shaw is one of the most distinguished international legal scholars in the world. His textbook on international law, published by Cambridge University Press, runs some 1,400 pages. He is really the lead scholar in international law in the world today. And I hope the court will take his jurisdictional argument very, very seriously. Clearly, South Africa had no business bringing this case against Israel. Whether it was done at the behest of Iran for financial reasons or for ideological reasons, there is no reason why the court should have entertained this case.
1948 Genocide Convention, Article 2. Destroy in whole or in part a national, ethnical, racial, or religious group. As I see it, Hamas does not fall under these categories. Correct?
If you're talking about Hamas as a victim, correct. If you're talking about what Hamas did on October the 7th, Hamas intended to destroy in whole or in part the Jewish people and the state of Israel by virtue of their attack.
Okay.
I think, sorry, Sylvia, the argument is not that Israel is eliminating Hamas, it's that they're eliminating the Palestinians as a so-called racial people. I don't think Israel has disputed that the Palestinians are a people. But South Africa goes further. They say Israel, ever since 1948, Israel has been on this ongoing intentional campaign to eliminate the Palestinian people. And the Gaza conflict is just the latest iteration of this policy.
Yeah. May I address that for a second, Andrew?
Sure.
First of all, as I said before, between 1948 and 1967, Egypt occupied Gaza and Jordan occupied the West Bank. And when Egypt occupied Gaza, Egypt maintained an extraordinarily brutal regime in Gaza. There was a dawn to dusk curfew for many years of that occupation. Many Gazans wanted Jordan to invade and take over Gaza and oust Egypt. And meantime, on the West Bank, the Jordanian occupation was no picnic either for the Palestinians. East Jerusalem was viewed as a backwater by Abdullah and his grandson, King Hussein, who succeeded him. That's number one. Number two, just look at population data. After Israel became the occupant in Gaza, and after Israel became the occupant of the West Bank, the Palestinian population in both places has grown dramatically, as has the population of Arabs living within the state of Israel. That doesn't seem consistent with a genocidal intent. And so I'll just leave it there for you.
Yeah. Are anti-Israel NGOs such as B'Tselem, Breaking the Silence, active in The Hague against Israel in this case? They're supposedly financed by the New Israel Fund.
I'm not aware of any of the Israeli-based NGOs that you mentioned, or any of the foreign NGOs, Jewish Voice for Peace and so forth, New Israel Fund that you mentioned. I'm not aware of any of them playing any role in the genocide case, and none of them have filed any pleadings in the advisory opinion case.
Thank you. Did the Israeli legal team refer to the Oslo Accords dispute resolution terms in their arguments on jurisdiction, lack thereof, at the hearing? I don't recall that they did, but I could be wrong.
Yeah, so on the South Africa case, they would not have referred to it because that's not relevant. Where it's relevant, of course, is in the advisory ruling on the legality of the occupation. And the answer is, I don't know what is in the Israeli brief because the briefs have not yet been made public by the court. When we hear the arguments on February the 19th, which will span a few days during that week, then we'll have a good sense of what the Israelis are arguing.
Andrew, would you like to add anything at this point? I see there are many, I see there are many people raising their hands, and we kindly ask you to send us in your questions in writing in the chat, and we will try to relate to all of them, please.
By the way, if we run out of time and some people are not able to get their questions answered, I will be more than happy for Andrew to email them to me, and I will respond to you in writing. More than happy to do that.
Perfect. Excellent.
Well, I'd just add one comment to what Steve said in relation to, for example, the ICJ proceedings on the advisory opinion. The problem is that the UN General Assembly system is kind of biased against Israel. So the very fact that the question was put to the court, that resolution was adopted by only a very, very small minority of states, I think 88 states, which is less than half, but because a lot of states abstained or didn't vote, the resolution gets passed and it gets to the court. And what ends up happening is the court then gets submissions filed by 55 of those 88 states, which by definition are hostile to Israel. And all the other states, which never say anything, don't file anything. So the court gets before it this raft of information and arguments, which are put really by one side, backed up by all the UN committees and council reports, which again are created by this minority or small majority of states. And so this kind of reality, legal and historical reality that's been created within the UN bubble is reinforcing itself and presented to the court. Now, when you think of those 17 judges who Steve talked about, 17 in the genocide case, 15 in the advisory opinion case, they don't know any better necessarily. They're not historians of Israel's history. They're dependent on the information that's given to them. So the whole system is very much swung against Israel's case. And when Israel doesn't argue its case, and again, we don't even know in the advisory opinion proceedings whether Israel is putting a case. I don't think it has submitted anything yet to the court. So there's very few states that are going to present arguments that are supportive of the state of Israel, which is so important that a number of them do that. Thank you.
I would also mention that only countries are allowed to file documents in the International Court of Justice, but in the advisory opinion case, the court allowed the Organization for Islamic Cooperation to make a filing, but rejected a similar request from the World Jewish Congress, which gives you a sense of how the court is stacked against the state of Israel.
Wow. Okay. Next question. Could you please elaborate further on the standard of proof required by the ICJ to grant injunctive relief in comparison with the standard typically used by US courts for this purpose?
Yeah, as I said, at the ICJ at this stage of the proceedings, is a very, very low standard. Are the allegations of genocide plausible? In the United States, the standard is you have to show the judge that you are likely to win your case on the merits, that you are likely to win. Likely to win is a much higher burden of proof than mere plausibility.
Okay.
So if I can just add here, look, where this has come up has been in the Ukraine situation and Myanmar situation and the former Yugoslavia, right? The difference here, I think, the distinguishing feature of this, Israel is fighting a legitimate war of self-defense, right? Everybody agreed to that after the 7th of October. And it's sometimes argued Israel has no right to self-defense. Well, I think that's a very false view. Israel is a state and it has an inherent right of self-defense against armed attacks against it. The court in 2004 said something different. I think that position has been disproved since then. But assuming Israel does have this right of self-defense, it's fighting a legitimate war. So the whole genocide claim and this was one of Israel's key arguments, that the genocide claim is completely misframing what is going on. We're talking about a legitimate armed conflict where Israel has a right to use force. It must be proportionate, must be necessary, it must comply with the rule of distinction. You can't go after civilians and so forth and so on. But it's those rules of international humanitarian law which should govern the situation, not the rules of genocide. And the South African claim is completely creating this kind of idea that Israel is this sort of horrid, nasty, malicious entity that is using the 7th of October as an excuse to eliminate the Palestinians. And this is why the low threshold makes it so problematic, because how is the court going to, even if it accepts Israel's narrative and rejects South Africa's narrative, will it, given that threshold, be able to throw this case out?
Yeah, going to be difficult given the Ukraine precedent in Myanmar, the others you mentioned. What we're seeing, as you said, is the weaponization of the Genocide Convention against Israel and the weaponization of international law more generally against Israel. One footnote about the Ukraine versus Russia case: the court voted 13-2 to indicate provisional measures against Russia. The 2 no votes in that case were the Russian and Chinese judges. Now, there you had Russia invading Ukraine, firing missiles indiscriminately at civilian targets, shopping centers, train stations, etc. That is not what is happening in Gaza, nothing remotely similar. Yet I expect that the same 2 judges, Russia and China, will vote in favor of South Africa in this case.
There you go.
Interesting. So we'll take a few more minutes to answer some of the questions because there are many questions coming in. So we'll take the opportunity to answer them. So there are 3 from the same person. I will tell them together. What will be the next steps and when? How does Germany's third-party intervention work? And are there any other countries that will intervene as a third party?
Okay, in the most recent case, Ukraine against Russia, the court issued its ruling only about 3 weeks after hearing the arguments from the parties, and could be any day now, next week or 2 or 3, that the court will issue a ruling in the South Africa case. Germany's intervention, relates to the next phase of the proceedings, which will be the exploration on the merits of the South Africa claims of genocide against Israel. And I think that we should all applaud the German government for its courage and for its moral commitment to standing up and doing the right thing. The United States has also flatly rejected South Africa's allegations. I hope the U.S. will become an active participant. And Prime Minister Justin Trudeau in Canada recently made a similar comment saying that the allegations are without merit. I hope Canada will make its voice heard as well, and other countries too.
Will the emerging evidence of embedded military use by Hamas of hospitals, schools, and other civilian infrastructure to launch rockets be of evidential use is rebutting the intent element?
Yes, and Tal Becker went into that in great detail in his argument a week ago Friday. I also saw a question that related to this in another way, and I wanted to mention that Tal Becker did play an audio tape for the court, that terrible telephone call from one of the terrorists to his parents saying, "I just killed 12 Jews, aren't I, wonderful?" And the parents celebrating. You can hear them on the call. And the Israeli government did supply the court, not for public consumption, but did give to the court the 43-minute video containing the captured images from the GoPro cameras and the surveillance cameras so that the court could see for itself what happened on October the 7th.
I think this will be one of the last questions, and we will wrap up.
Add to that. Yeah. There were 5 presentations on behalf of Israel, and they do go very much into great detail into Israeli measures to minimize civilian casualties.
Yes.
The very, very detailed presentation. And indeed, the point that Steve just mentioned about Hamas embedding in civilian infrastructure and so forth. All is indeed argument that the high number of casualties is a result not of Israel's actions, but of Hamas's strategy.
Does the South African case make any reference to the hostage situation? Is there any relationship between this case and the hostages taken on October 7th?
Yes, Tal Becker did mention the hostages at length in his and the other Israeli lawyers as well. Yes, absolutely, yes.
Yes, but the question means refers to the South African case.
That's what I'm referring to.
If they took, okay.
Yeah.
Do the South Africans talk about this?
Oh, I'm sorry.
they
Forgive
relate
me.
to it?
Okay. Now I
Yes.
misapprehended. Yeah, forgive me. So I misapprehended the question.
No. Oh, good.
South Africa's December 28th filing at the ICJ is about 80 pages, single-spaced. Two short paragraphs refer to October the 7th. That's it. Nothing else. Nothing else. It is shocking that a party would ask the International Court of Justice to undertake a case without telling the court what precipitated all of this. It is shocking.
It really is. Perfect. So I think that with this we will come to a close. So Andrew?
Okay. Well, there's a whole bunch of issues I think that are still underlying all of this. The right to defense of Israel. I think this is something we need to dig into. Some people are still denying the right of Israel to self-defense, the issue of proportionality. But I think the two-state solution is also something. We keep seeing people calling for the two-state solution as if Israel's actions are somehow preventing a two-state solution, and a two-state solution is going to solve the problems that are being precipitated in Gaza and in the West Bank. These are issues we also still need to get into. So I want to thank you, Steve, for your wonderful presentation. I do encourage people to send us your questions by email. You can find us on our website at info@thinc.info. We will deal with those questions, and where necessary, we'll pass them on to Steve Zipperstein, who's, as you said, very willing to answer your questions. And together, we'd like to help you and help all of us grapple with these issues. Please do share our work. Share the upcoming webinars and all of our articles with others in your social media networks. Like us, share us, and donate to our work. We need you. We need you to support the work of thinc, to get out a better understanding and a balanced and a fair understanding of how international law works and how the position of Israel is so much under threat at the moment. So thank you again for your attention, and look forward to seeing you at our next webinar. If you haven't, by the way, signed up on our website, www.thinc-israel.org. That's think with a C, -israel.org. Sign up for our e-bulletins, and we'll keep you informed about upcoming events and information. So thank you all so very much.
Thank you.
Thank you. Good night.